SJC-11988, Commonwealth v. Daniel Francis.
Good morning, Mr. Rotundo. Just give us a moment. Okay, you may proceed.
Good morning, Your Honors. May it please the Court. David Rotundo for Mr. Dan Francis. Also with me today is Mr. Ben Selman of CPCS, who filed an amicus in this case and will be taking a portion of the argument. In this case, the appeals court applied their decision in Commonwealth versus Gaston and extended this court's decision in Commonwealth versus Scott, the conclusive presumption of egregious government misconduct to a defendant convicted after jury trial. Now, Dukin defendants convicted after jury trial have never been addressed by this court. So as a preliminary matter, we would ask that that conclusive presumption of misconduct be applied to defendants convicted after trial.
Well, I take it in this case, at the trial, had nothing to do with whether the stuff was drugs or not, right? The defense was, it ain't mine. Or am I wrong?
I'm sorry?
What was the defense at trial to this case?
The defense was that he was not in possession of the substance.
That wasn't his.
It wasn't his,
Right.
correct, correct.
Okay. That was his defense at trial, and then when he was arrested, he essentially confessed to regularly selling a certain amount every week and a half
That's
of that drug.
correct. But, and the appeals court found that the admissions that were made during the trial would have not been a real factor in the jury's deliberation, even considering the Dukin evidence. Now, assuming for the moment that these admissions may bear somewhat on the composition to some extent of the substance, there is absolutely no independent evidence in this case that can prove the weight of the substances. Now, the defendant was convicted of trafficking over 28 grams. Now, the drug certs allege a total weight of 40 grams of substance, which is only 12 grams over the threshold requirement. So it's our position that even assuming there were admissions made in this case, there was no independent testimony that can shed light on the weight of the substances. There was some testimony from Officer Piraway about various exhibits, and he testified that he didn't know how much they weighed. The prosecutor, on direct examination, asked some questions. He stated that there was approximately 28 grams of cocaine before you. Can you estimate the value? And
How much is a quarter of a kilogram? 250 grams?
250 grams, I believe.
Okay. So that's what he said he sells every week and a half.
He did, well,
Quarter to a half of a kilogram every.
well, even, even taking those admissions into account, there was no way for the jury to determine what the drugs at issue in the case, the weight of the drugs. There was no evidence where they could make it. It wasn't a case where there was 2 ounces of substance before them and they could give a lay opinion as to the weight. So
So I'm sorry, so help me to understand, how are we to look at this? This, of course, occurred before the Dukin wrongdoing was revealed, correct, the trial?
Yes.
Yes.
The trial occurred before anybody knew about Dukin's
correct.
wrongdoing.
That's correct.
So we are to look at it in terms of what would this have affected the jury if the jury had known of what the judge would told them is egregious government misconduct? Is that?
Well, I
how we
think
look?
that first of all, the drug certificates would have been vigorously cross-examined with regards to the weight, where Dukin was found dry labbing, contaminating samples, et cetera. And I think as far as the, regards to the weight aspect of it, that that evidence would have materially influenced the verdict.
Now, have we spoken about the admissibility of evidence that relied upon Dukin as the assistant analyst?
I believe we have in Commonwealth versus Scott. I believe
That was, of course, was a plea, so there was no.
No,
it wasn't-
in other words, if you had the evidence, would the certificate still come in subject to cross-examination? That's your, right, I think. We haven't spoken about that, have we?
If we had the evidence, would the certificate still have?
In other words, if you had known, if you had known about Dukin's misconduct at the time of this trial, so you've got you've got the certificates. One answer might be, well, they can't possibly come into evidence because of this misconduct. Another could be, they come in, but they're subject to all the cross-examination, right?
Correct. And either way, if the certs did come in, even subject to cross-examination, I believe that the difference in the weights would have swayed the jury into having, would have been a real factor in their deliberations. Now, with regards to the admissions in the case.
Before you leave that, standard of review, do you accept the Gaston analysis, that it's a real factor analysis, or are you saying that where we find there to be, which I think is where the amicus is going, well, they want us to go all the way, but their alternative argument, as I understand it, is that where there is egregious government misconduct, that is a due process violation, and therefore we should apply harmless beyond a reasonable doubt because it's a constitutional violation for the government to have
Correct.
engaged in egregious government misconduct. Is that your position?
That is also our position, and I was going to defer that portion of the argument to Mr. Selman. I think under that standard of error, I think in light of the Commonwealth versus Montoya case, I think it's the case becomes very easy to decide. Now, with regards to
But you say you still win even under the real factor analysis.
well, I am arguing that, correct, under the newly discovered evidence standard in Grace, whether it would have been a factor in the jury's deliberations, these admissions. Now, I'd like to just, before I think I'm running out of time here.
No, you're not. You have
you got 2.5
2.23
minutes.
minutes left.
2 minutes?
2 minutes, 2.5 minutes
I
to
think I'm
go.
going to have to defer.
No.
Oh, that's my time.
That's your
Yeah,
time.
that's your
Okay,
time.
okay, I'm sorry. Now, the admissions in this case, it's our position that they weren't really admissions at all. I mean, Officer Reed testified defendant admitting to selling between a quarter and 1/2 kilograms of cocaine per week. So that admission does not go to does not have anything to do with the composition of the substances that were found, that were
So he could have been
indicated in
selling,
the
he
drug
could,
search.
he could have been in the business of selling phony cocaine, I suppose is what you're saying.
That's true, or whatever it
Wouldn't
may
be in the
be.
business
Now,
for very long.
now, furthermore, the defendant testified.
Is there evidence in terms of the context? I got the impression from the briefs that he was seeking to, or that they said basically, will you help us find the dealer? Was that part of what occurred at trial? Or, I mean, was he invited to cooperate and refused it? Did that come out during the course of trial?
He didn't refuse, it just never
But no, I
materialized.
think that's what he had, in the appeals court found that the admission was related to him trying to set up some type
But
of
what came
sting operation.
What came into evidence at trial? Did it come into evidence to say, I'm a big-time drug dealer, I can help you find my dealer if you cut me a
Yes,
deal?
and that was related to the between a quarter and 1/2 kilogram, that statement. Now, the defendant testified that he was approached and showed a substance and asked if he knew someone who would purchase it. He never admitted that it was cocaine. Now, only on cross-examination, he was asked another question by the Commonwealth. The question was, Henderson showed you a piece of crack and asked you if you knew anyone who would purchase it. And his answer to that compound question was yes. And it's our position that that assertion does not amount to an admission by the defendant that this substance was cocaine. And I would ask the court to adopt the same standard as in cases where erroneously admitted certificates have been deemed harmless beyond reasonable doubt. In those cases, the admission would have to include specific details of habit or addiction that would establish a basis of knowledge from which the defendant could reliably identify a given substance. In this case, we don't have that type of admission. And so I would ask that for the standard of proof required for an admission, that it would be something more than a mere assertion as in the present case.
I think now your time is up, so thank you.
Thanks.
Mr. Selman, we're not diminishing your time for the time that Mr. Rotundo took, so you've got your full 5 minutes.
Thank you, Your Honor. May it please the court, Benjamin Salmon on behalf of the Amicus Committee for Public Counsel Services. Once again, this court finds itself confronted with the product of a widespread scheme of habitual, deliberate falsification by a government agent. And once again, we respectfully urge this court to exercise its superintendent's power to rectify this problem. As set forth in our amicus brief, CPCS is requesting that this court order one of two remedies for defendants who went to trial and were convicted based on evidence generated by Annie Dukin. And these two alternative remedies are: one, automatic vacator, a rule that you went to trial on a Dukin certificate and were convicted, you get a new trial, period. In the alternative, we would ask the court that they ask the court to issue a rule that in the post-conviction context, the Commonwealth be required to demonstrate that the admission of the Dukin evidence was harmless beyond a reasonable doubt. Twice before, CPCS has requested this court enforce a global remedy to deal with the Dukin solution, and twice this court has declined to. We respectfully submit that if there is any class of cases where automatic reversal would be appropriate, it is this class of cases. It is cases where defendants went to trial and were convicted. The reasons for this are twofold. The first reason being that we're dealing with a much smaller body of cases than the entirety of the universe of cases which were touched by Dukin's conduct. The number of cases which went to trial is undoubtedly much smaller than those resolved by pleas. Secondly, it makes sense to enforce this rule. In Scott, this court set forth a reasonable probability of going to trial as a sort of gold standard against which the merits of a motion for new trial are to be judged. In a case like Mr. Francis's, where he went to trial, he should get a new trial. A rule requiring automatic vacator would be consistent with this court's prior jurisprudence in this respect.
Now, are there other cases, putting aside the first argument with regard to the second, where there is egregious government misconduct? How have courts treated that during the course of trial?
Your Honor, the Annie Dukin scenario is unique as far as I'm aware. There is not case law on what happens if there is a widespread scheme of egregious
No, but what just in an individual case of egregious government misconduct?
There have been cases in which police officers have been found to have lied or have to be concealing evidence. I mean, there are cases of egregious government misconduct before.
Correct. I would submit that many of these cases deal with withheld exculpatory evidence in which the prosecutors are implicated in the withholding of the evidence, and we don't have that in the context of Annie Dukin. With respect to Annie Dukin, the prosecutors did not know about her wrongdoing until everybody else did. The judges did not. So If we look to the line of Brady versus Maryland cases, which I believe speaks to the question the court has proposed, it doesn't really help us because those all turn on the prosecutors being privy to the misconduct or being part of the misprision of the misconduct. We don't have that, and Brady versus Maryland doesn't help us in this case. I see my time's running out. I would respectfully...
But are there cases, there must be cases in which police officers were found to have lied during the course of a trial. What has been the standard that is applied in those cases?
Your Honor, I am not aware of such cases. I have not, or at least in my research on this issue, I did not come across this particular scenario. I think what you would have is you would find, well, I'm sorry, let me step back. The standard would be the newly discovered evidence standard, generally, if it's not a Brady versus Maryland violation. And the court would apply the Gray standard, which is what the appeals court applied in Gaston. And I would submit that with respect to individual instances...
We apply the newly discovered evidence standard where it turns out that the police officer falsely testified?
I
And that
believe
was
so,
later
Your Honor.
discovered?
If there's evidence that false testimony was introduced at trial...
Not merely erroneous, but knowingly perjured.
Correct. This would be broadly under the newly discovered, this would be newly discovered evidence. At trial, we don't know the witness is lying. Something happens afterwards and we learned, well, officer so-and-so lied on the stand in a material way. This is newly discovered evidence and it fits in the Gray standard. The problem with the Gray standard with respect to Dukin cases is that Dukin misconduct is in a class in and of itself. We cannot, and this court has already recognized that an individual defendant can likely not demonstrate whether or not Dukin falsified in his particular case. So this is of a class different from a case where a single witness has been found to have committed perjury in a single case. Due to the widespread nature of Ms. Dukin's misconduct, due to the fact that we cannot reconstruct it, this court must exercise its superintendent's power. The Gray standard is simply not enough, and CPCS respectfully urges this court to adopt one of the two superintendent's remedies we have proposed.
All right, thank you.
Thank you very much.
Good morning, Your Honors. May it please the Court, Vincent Demore on behalf of the Commonwealth. I'm asking this Court to affirm the Appeals Court's ruling, which was affirming the motion judge's finding that the defendant is not entitled to a new trial. I think, as a first question, whether or not the Scott presumption doesn't, because my reading of Gaston didn't really, as I read Gaston, I would not say that it extended the Scott presumption. I think it should. Frankly, I think this court should, whatever happens with this case. I don't see how one can come to a different result than that, which would essentially grant, I remember at the time I argued it'd be granting a greater benefit to those who admitted their guilt versus those who challenged their guilt, and I think my position remains the same with regard to that. So I do think this court should extend the Scott standard. In any event, the Appeals Court certainly assumed that was the case, even without finding it necessarily was the case here. So then I think in terms of what we're left with at that point is, and I think Judge Gaines, I think really hit on the question as to where do we go from there, right? Is it the Gray standard of the newly discovered evidence, or is it something greater than that? And I think I would suggest that the newly discovered evidence here is of egregious governmental misconduct. And I think the Dukin cases in general, I would agree with Mr. Selman, do present a unique scenario, in part because the egregious governmental misconduct, and I hope the court doesn't misunderstand me from what I'm about to say, doesn't necessarily in any given case exist in fact. It's essentially a construct we create. So it's not like a police officer who was deemed later to have perjured himself or some manufactured piece of evidence, because the misconduct itself, candidly, in terms of what occurred, is not so much the falsification of results, because in fact we can empirically demonstrate one way or the other whether or not a given set of results was indeed falsified, as it was the dry labbing. I did tests X, Y, and Z when I didn't actually do tests X, Y, and Z. And you can essentially make that statement and be correct. It's just wrong in the sense that you're representing you had made those tests. So I think when we look, what I would suggest is in the context of this particular case, I think we have to look to the trial record. And I think when we determine whether or not it would have been a real factor in the jury's deliberations, I think we have to look at what happened in this particular trial. And I think this particular trial also presents a very, very unique set of circumstances based on the dates here. So this occurred prior to Melendez-Diaz, and it was later determined that, in fact, Melendez-Diaz would not be retroactive to this particular defendant. So the certificates of analysis were admissible by statute here and didn't get the benefit of the retroactivity of Melendez-Diaz just based on the dates. So I don't think what we do is, I don't think we excise out the drug certificates because they are themselves independently admissible. And if they weren't admissible, I would agree with counsel that there is not sufficient evidence to demonstrate that, in fact, the substance was cocaine. I think there's compelling circumstantial evidence that it's cocaine. I think, you know, any one of us could say it's probably cocaine, but I don't think for the purposes of proof beyond a reasonable doubt in the harmless error analysis, I don't think that the evidence here reaches that point.
Really?
I don't.
Drug dealer, I sell half to a quarter to a half a kilogram every week and a half. You want me to give you my dealer? I mean, this is not someone, this is not a sort of a street guy who's got a little thing in his pocket.
I wish that were the case, but at least my review of the case law is that admission in the past has not been sufficient. There needs,
Well, it's
needs
not
to be.
scientific, but it's also, God, I don't know what's in that can, could be, I don't know. I've been selling this stuff for quite a while. I sell a lot of it, but I have no idea what it is.
And I think in this particular case, as to whether or not the misconduct would have been a real factor in the determination, I think that's a major factor. It's not merely that I move that much product on a weekly or week and a half basis. It's that I get it from the same source in the North Shore on a regular basis.
Yeah, but on the weight, I mean, at any particular time, why don't you think, if the certificates are before the jury,
Yes.
and they are suspect, particularly on the weight question, why wouldn't that be a factor?
Well, I think that the weights aren't close here. It is 1/3 greater than what was the threshold level. And if in fact that is the court's decision with regard to that discrete question, I think it would simply result in a conviction for possession with intent to distribute and a resentencing. But I think that factor, coupled with Henderson's testimony in this case, the buyer testified as well and indicated that he had in possession cocaine. And if he had, I think with regard to the harmless error analysis, if he had testified that he himself had ingested some portion of it and received the psychological effects or neurological effects that came with cocaine, I think that would be enough. My review of the case law appears that essentially is what's required. But I think when we look at the context of this particular record, and it's not merely that it wasn't the defense at trial, in the sense that it was argued to the jury, but it was the evidence submitted to the jury was that the drugs were in fact not mine. It was this other guy, Henderson, and Henderson came and he testified that yes, it was cocaine and yes, it was mine.
Have the drugs been reweighed here?
I do not know. I don't believe anyone has requested that.
Do they exist? I mean, this is 2006, right?
I don't know for sure, but they probably do. It was a Boston police case, and the depository at Hyde Park, in my experience, still has, we're very bad at destruction orders. It still has about 95% or so of all the samples.
Okay, let's say hypothetically they exist and they could be reweighed. And if they were reweighed and found to be 40.04 grams, which is what the 3 certificates say, should that be factored into the analysis?
Yes, I think if there were an
Because if you got a new trial and it was reweighed,
No, but one of the issues that she, I mean, unlike the fact that they are cocaine, because,
Yeah.
but on the weight, if she says I was adding stuff, you don't know whether she added stuff to these.
Well, my understanding of the allegations with regard to what she, or not allegations, her conduct, with regard to the weight was not necessarily adding weights or subtracting weights. It was more of an issue of tearing the scales. So ensuring that the scales were properly calibrated in essence, which can result in either it showing up as heavier or lighter. And when we've done retests, we found that the weights are not statistically significant differences in the weights. There's always going to be some difference in weight because cocaine is partly water and it evaporates over time.
Okay, but is that, if we had that information, would that be something that we could legitimately consider on the question of whether or not to grant a new trial?
I think if there was an evidentiary hearing in this case and the government presented as sort of countervailing to the misconduct, that the weights are the same, I think the court should be able to consider it. I'm not sure it could, though, if the Scott presumption is extended, because that's a conclusive presumption of misconduct. So I think that's, and I mean it with all due respect, a weakness in the Scott presumption, that even when it is possible to sort of empirically prove or to present evidence that's case-specific, that case-specific evidence goes by the wayside against the Scott presumption. So while I think it should be something that can be taken into consideration, I'm not sure the Scott presumption would allow for it to be taken into consideration.
So let me ask you the same question I asked your brother. How are we supposed to look at this? We do have the conclusive presumption. I think you quite appropriately agree that that's what we have to do. It's of government misconduct. Is that a due process violation for the government to engage in egregious misconduct, recognizing the peculiar circumstances here where there was no claim of prosecutorial misconduct?
I think there has to be that showing of materiality in order for it to reach that level. The same that we see in the Brady analysis, the same that we see in the newly discovered evidence analysis too. I think the case where it's
Materiality means what's our standard then? So
I think the real factor standard is the appropriate standard here, and I think
where does that come from? Real factor
from
standard?
Grace. I think from the newly discovered evidence.
That's the newly discovered
Yes.
evidence.
And I think in this case,
And therefore, it doesn't matter if it was you're saying then that the fact that the government engaged in misconduct is irrelevant here. All that matters is that it's newly discovered evidence.
no, I don't think it's irrelevant. I think it is the misconduct. It is the newly discovered evidence. So it's not. I think they're sort of one and the same.
No, but my point is that if it was newly discovered evidence because something was unearthed,
It's not an aggravating factor, I guess is would be my answer to the
question
question.
is should it be?
I don't think so, because I think, and I think my brother's correct, this is a very, very small universe of cases here. I don't think a sweeping rule is really required, because I think we
We don't
can.
have any way of ballparking what it might be, do we? Or do we, at this point?
Well,
based on-
I can speak for Suffolk County. There was Gaston and there's this case in terms of litigated motions for new trial. And I tried very hard not to litigate Gaston in the first instance. It was a gun case in my perspective, not a drug case. So this case really does present a very unique set of facts. It's a very rare case where someone goes to trial allegedly having made those admissions to the police, having the buyer testify on his own behalf, having not raised this at all, having a case which is pre-Melendez-Diaz and hasn't already been wiped out anyways from that whole process. It may be a class of one in Suffolk County, at least, in terms of the cases that exist.
Now, with regard to cases where it is discovered that police officers lied, what standard do we employ? The newly discovered evidence standard or something other?
I think the newly discovered evidence standard is appropriate there. I think it would be depend upon essentially the nature of the lie within the context of the trial record. There will be some lies, perhaps many lies, that will be dispositive. The defendant confessed to me, and in fact he had not. Or I observed the defendant commit the crime.
Dispositive meaning?
Of the motion for new trial, meaning that it would be impossible for the government to overcome, in essence.
Impossible only because it would plainly be a real factor, you're saying.
Exactly.
But in terms of the standard that would be employed, you'd say it would still be that we have used a real factor analysis even when the newly discovered evidence is that the government engaged in misconduct?
Yes, yes. And the cases that come to mind where that's the case, however, well, I'll say this. I think it's very rare this court is ever really going to see those cases. And I don't mean that to say that the police are all angels, although, I'm not suggesting the contrary either. I think it's the case that for the most part, there's sort of a screening out that occurs before these cases ever get litigated. If as had been the case in the past, when we discover that there's been some misconduct that rises to that level, usually it's the government that's stepping forward. And I can tell you in the context of the Dugan cases, there are more null process with my name on it in the Commonwealth than anybody else at this point, for whatever risk that brings to me later on down the road. There is a very, very strong, essentially, presumption we operate under. If the defendant contested his guilt at trial, we're essentially vacating those convictions regardless. This is just a very, very unique set of circumstances that led us to come to the opposite conclusion. And if the court has no further questions, I'm happy to rest on the papers.
All right, thank you.
Thank you.